Mr. Lordships, Lordships, I beg to mention item 23. I'm making mention on behalf of the House of Films, Mr. Tagliao. Lordship, here's some difficulties. Item number 2 weeks ago.
2 weeks.
There was
Heard Mr. Fonseca Forte, learned counsel, submitting on behalf of me. Mr. or Miss Taliao?
Mr. Tagliao.
Mr. Taliao, learned counsel for the appellant who seeks an adjournment on the ground of personal difficulty. Learned also heard Miss Learned Central Government Standing Council. Zedang Zadangoli as Miss Vishokre, learned additional AG Nagaland, who does not oppose the prayer. Hence the prayer let this matter listed after 2 weeks.
May I please, Your Lordship? May I please, Your Lordship?
Yes,
My Lord, I seek Your Lordship's indulgence in item number 24. I will require an 1 week accommodation with respect to filing of my rejoinder.
Lordship, in that case, the learned AG is not keeping well, so I pray that the matter may be listed on 27th of August.
Now, let me file it on after a week, so that after that you can take a time. Let me file it on by a week. My Lord, may kindly post the matter on a day.
Lordship, matter can be fixed on 27th, so that in the meantime he can
27, it will be I will be having a difficulty, ma'am.
even if it is listed or
we are not fixing a date.
My Lord.
Let him file rejoinder.
My Lord.
Heard Mr. S. Borgohain, learned counsel for the petitioner. Also heard Ms. V. Sokre, learned additional AG. Learned counsel for the petitioner has sought some time to file affidavit in reply against the affidavit in opposition filed by the respondents. On the other hand, learned additional AG also has sought an adjournment on the ground of indisposition of the Advocate General. Considering the submissions made by learned counsel for both the sides, let this matter be listed after
After a week, my Lord, let it be after a week.
make it on
Let the
27th,
pleadings.
because-
No, what I propose is that let the pleadings come on record. Let it be closed. After that, we can fix a date for a hearing.
My Lord, my AG is not keeping well, so Lordship, I pray that the matter may be fixed on 27th.
27, I have difficulty, my Lord.
Then if that is
Except for a week, after a week.
of September, 3rd of September, if 27 is not convenient.
let the matter be listed on 3rd of September.
Much.
Well,
Lordship, I beg to mention item 25.
3rd September 2000.
Yes.
Yes, Lordship, I pray that this matter may be listed next week along with WA 6 of 2025. I've taken the consent of the opposite party.
Heard Ms. V. Sokre, learned additional AG, appearing for the appellant, who seeks an adjournment
1 week.
for 1 week. The counsel for the respondent side does not oppose the prayer. Hence, let this matter be listed after a week.
Along WA 6 of 2025.
After a week, on a date to be fixed by registry, along with writ appeal number 6 of
2025.
2025.
May I please, Your Lordship? Lordship, I beg to mention item number 7 on behalf of Tikapon. Lordship, regarding this matter on DD August.
When?
20 August, my lord.
20,
Yes,
No.
my lord. Next week.
item number 7.
Item number 7.
Heard Mr. Senti Younger. Also heard Miss
Bichano on behalf of Tipafong.
Pichano, submitting on behalf of Mr. E. Tibafom, London Government Council. Also, what's her name?
Correspondent number 5.
Also, Ms. K. Lilisu, appearing for respondent number 5. London Government Council prays for listing this matter on 20th of August, to which the counsel for the petitioner has no objection. Hence, let this matter be listed on 20th of August.
Much obliged.
Lordship, similar prayer with item number 17 and 18 on behalf of Tipafong. Turning this matter after 2 weeks. Lordship, 18 and 19.
18 and 19.
Lordship.
Lordship, I'm free. Appellant in item 18. 19.
Heard Ms. Pichano, London Council, appearing on behalf of Mr. E. Tibafom, London Government Council, who seeks an adjournment for 2 weeks only.
This can be taken up after one week.
Let it.
Considering that the writ appeal also is of 2022 and the writ petition, where the petitioner is of 2020.
Also heard Mr. Foseco Forte, Learned Counsel for the writ appellant, Learned Counsel for the appellant, as well as Mr. T. Kezi, appearing for respondent number
4 in writ appeal and the petitioner in item number 19.
Write the name of the council after seeing the cause list. Let this matter be listed after a week. After a week on a date to be fixed by registry.
Lordships, I beg to mention today item number 20 and 21. Mentioning on behalf of my senior L. Iralo, he has difficulty to breathe. Pending is the matter of 2 weeks.
Lordship, I may suggest today, 3rd of September, after 3 weeks. This petition respondents are 3 weeks, and then that can be on 3rd of September.
Okay, heard Miss
I'm pretty appellant.
Menoshino, Learned Council, submitting on behalf of Mr. L. Iralu, Learned Senior Counsel, appearing for respondent number
In item number 20, I am for respondent 1, 2, and 3.
1, 2, and 3. Item number 21. Okay, write the names after seeing the cause list. Who seeks an adjournment on the ground of personal difficulty of the senior counsel, Mr. L. Iralu. The counsel for the petition appellant does not oppose the prayer and suggests that prays that the matter may be fixed on 3rd of September. Accordingly, let this matter be listed on 3rd of September.
For motion, item number 1.
This, Your Lordships, this matter pertains to posthumous regularization. Petitioner died in harness of work charge employee after serving for more than 26 years. Then the wife submitted representations, several representations praying for posthumous regularization and at least fund of pension.
Yes. Ms. Pichano. We are issuing notice. Heard Mr. T. Pongner, learned counsel for the petitioner. Also Ms. Pichano, learned government counsel, appearing for all the respondents. This writ appeal has been filed by the appellant Srimati Nyas Shula Sanktam, impugning the judgment and order dated 26/2025, passed by learned single judge of this court in writ petition number 332/2023, whereby the prayer for posthumous regularization of the service of the husband of the appellant was rejected. Let the notices be issued. Since Ms. Pichano appears for all the respondents and all the respondents, no formal notice need to be issued to the respondents. However, the petitioner shall furnish requisite numbers of the copies of memo of appeal along with annexure to the counsel for the respondents within
5 days.
within 5 days from the date of this order. List after 4 weeks.
For motion, item number 2.
So now.
Other billing separate. Others will remain same, only this writ appeal has been filed by the petitioner, Srimati Kusolu, impugning the order dated judgment and order dated same. Remaining narration will remain same. Other things will remain same after 4 weeks.
For motion, item number 3.
Please, your lordships.
Yes.
Lordships, the petitioner hearing is seeking for revocation of the detention order dated 8 April 2025. On the grounds that there is no mention in the detention order that the detainee is likely to be released on bail. And as such, the detaining authority did not have any subjective satisfaction to issue the detainee order. And further, my lord, the detainee does not know English. And the copy of the detention order and all the relevant documents are served to him in English. And this is gross violation of Article 22 sub-clause 5 of the Constitution of the law. Therefore, on these grounds, I am seeking for revocation of the detention order.
Yes. Heard Mr.
Yes, okay, ma'am.
A. Sophie, learned counsel for the petitioner. This writ petition has been filed by the petitioner under Article 226 of the Constitution of India, impugning the detention order number CON/PITNDPS/09/2025/107 dated Kohima the 8th April 2025, passed by Special Secretary to the Government of Nagaland, whereby the husband of the petitioner was detained. Guli. Learned Central Government Standing Council appears respondent number 2. And Miss Livika appears for
1, 3, and 4.
respondent number 1, 3, and 4. As the councils, as the above named councils have represented the respondents, no formal notice need to be issued to the respondents. However, requisite copies of the writ petition along with the annexure shall be furnished to the learned counsel for the respondents. When will you take instructions?
No, my lord, 2 weeks.
4 weeks is too long.
2 weeks, my lord.
No. Let this matter be listed after 2 weeks,
Let's make it 3 weeks, sir.
after 3 weeks.
From the supplementary cost list for motion, item number 26.
May it please your lordships. Lordships, by this petition, I'm challenging the detention order. Under.
We are issuing notice. Heard Mr. Pokim Yadin, learned counsel for the petitioner. Also heard Ms. Livika, learned government counsel appearing for respondent number 1, 2, and 3. This writ petition under Article 226 of the Constitution of India has been filed by the petitioner Srimati Amina Khatun, who is impugning the detention order number CON/PINT/11/2025/145 dated 5/6/2025, passed by the Special Secretary to the Government of Assam, Government of Nagaland, Home Department Political Branch, whereby the husband of the petitioner was detained. Issue notice. Sub. Since Ms. Livika has appeared for all the respondents, no formal notice needs to be issued. She seeks some time for seeking instructions in the matter. Accordingly, let this matter be listed
3 weeks, sir.
after 3 weeks.
Have the notice be issued to the respondent proposal.
Yes.
Union. Number 4.
Mr. Yangarwati, learned respondent number 4. Yes, Mr. Yangarwati, learned Central Government Council appears for respondent number 4.
Lordships, if I may make another prayer, I was previously released on bail. And I will specifically mention this in my petition also, but I've forgotten to attach the bail order. So if I may be allowed to place the bail order by way of an additional affidavit.
Learned counsel for the petitioner seeks leave of this court to file an additional affidavit to bring on record the bail order by which the husband of the present petitioner was released on bail. The prayer is allowed. He may do so before the next date fixed.
I'm okay, sure.
For admission, item number 4.
Mrs. Lordships. Lordships, as directed by this another report of 16/7, the state respondents as well as the NHIDCL has filed their compliance affidavit. However, Lordship, the affidavit filed by the Deputy Commissioner of Kohima, Deputy Commissioner Jurukutima, Commissioner Nagaland, and the affidavit filed by the Chief Engineer National Highway Nagaland. Or affidavit I received just now. So, Lordship, did it be after a week? Just received inside the courtroom. So I haven't had the
Okay.
time to go through that 4 affidavits received.
Any submission from the respondent side?
No.
Okay. Heard Mr. Takamasha, learned senior counsel, learned senior counsel who has been appointed as amicus curiae in this case. Also heard, write the names of other, Mr. T.B. Jamir for respondent number 19, Mr. M.T. Imsong for respondent number 3, 4, and 5. Mr. N. Muzoi, respondent number 15, Mr. Moazamir for respondent number 6 and 7. Learned amicus curiae has submitted that in pursuant to the directions of this court by order dated 16/7/2025, who has filed
Deputy Commissioners,
deputy-
Tumuktima, Hima, Commissioner Nagaland, and Chief Engineer National Highway Nagaland.
have filed the affidavit in compliance, and he seeks some time to go through the same.
Yes.
The prayer is allowed. Let this
Week.
let this matter be listed after a week.
On 20th, Lordship. On
20th is the Wednesday.
yes.
Okay, let this matter be listed on 20th August.
Thanks.
For admission, item number 5.
What is the matter?
Lordships, Your Lordship can peruse the order of on the court dated
25/6.
25/6. Yes. The pursuant to this order, the respondents 2 and 8, they initially said they have filed an affidavit. Have you Lordship got that on the call? Affidavit was filed on 22/7/25. 22/7/25.
Yes,
Can you go through the contents of the affidavit, the relevant portion?
yes, that
Which are in response?
affidavit. Take out the affidavit. Don't give.
Twenty-two, 7/25.
Yes,
We can start from paragraph 3. Paragraph 3 of the affidavit is not changed. Paragraph 3. That the expert committee at the bottom of the page 3 of the affidavit, bottom of the page, paragraph 3.
yes,
That the expert committee has visited the Pesama sinking area on Kohima. Has the Russian got it?
yes,
That the expert committee has visited the Pesama sinking area on Kohima Mao section during their visit from 23/6/25 to 26/6/25 and has submitted the report suggesting remedial measures for the sinking area. The report is in annexure 1, not necessary to go to that, stay to the next paragraph, Lordships. That restoration of the sinking is in progress at full swing following the interim measures as recommended by the expert committee. 5. Additionally, the expert committee has recommended modifying the interim measures to include multiple tiers of crib walls and extending the construction to the toe of the disturbed slope for better stability. This proposed measure would significantly exceed the earlier proposed ROW of 30 meters on the valley side, requiring an additional ROW of at least 70 meters, bringing the total to approximately 100 meters. 6, that the estimates for earlier proposed land for temporary restoration of the sinking area has been received, duly approved from the state government on 26/6/25. The same is under process for approval of competent authority with HQ and HRECL. After approval, the amount shall be deposited for Keller for to Keller for disbursement. This is important. I would like your worship to particularly note this statement. After approval, the amount shall be deposited to CALA for disbursement. So this is the competent authority under the Land Acquisition Act. Then 7, that NHRDCL has submitted that supplementary requisition for additional land as recommended by the expert committee by NHRDCL letter dated 1/7/2025 to DC Kohima. The proposed land has been assessed by the district administration on 7/7/25 and the estimates are under preparation by the revenue department. The estimates will subsequently be submitted to the competent authority of the state government for approval. Again, there's another mention of a competent authority here, which your Lordship may kindly note. 8, it is further mentioned that presently LMVs are being diverted through the route notified by the district administration via the Mori Cove, Jaffa Christian College, Kisama, Pesama, and vehicles are plying smoothly and commercial traffic up to 6-wheel trucks are in around Imphal is allowed for vehicles up to 10-wheel vehicles for Manipur bound traffic. That construction of palisades crib wall reinforced with the geobags and strengthened with geogrid is currently in progress on the valley side as temporary measure. So far, 8 steps have been completed and additional 7-8 steps subject to site conditions are required to reach the existing road level on the valley side. Additionally, hillside protection measures, including the construction of breast walls and soil healing, will commence during the dry spell, mitigating landslide risks. That the unpredictable weather conditions and intermittent rains have posed significant challenges, particularly as the work requires layered compaction, which demands dry spells. Despite these setbacks, work continues, and once weather improves, conditions improve. The pace of work is expected to accelerate, allowing for more efficient completion of remaining tasks. Approximately 25 to 30 dry working days will be required for temporary restoration, enabling vehicle movement. All necessary safety measures and temporary arrangements are in place to ensure uninterrupted traffic flow through diverted routes. As per the direction of this Honorable Court, to bring on record the aforesaid 2 guidelines dated 28/12/2017 and 10/5/18 issued by MOD for the acquisition of land under the National Highways Act 1956, the same are submitted for kind perusal of the Honorable Court. May I pause here for a moment, Your Lordships? This paragraph, now, under the National Highways Act, it is the duty of the central government to acquire land for the construction for the building of national highways. And for that purpose, a detailed guideline has been issued, which is the guideline dated 28/12/2017. Now we have many land issues in the state of Nagaland as far as the construction of national highways is concerned. The problem, Your Lordship, is because the MORTH and the NHRE said that the state government is not following this guideline.
That means it is not acquiring the property.
Yes, in accordance with law. And a process which is being adopted, which is not in accordance with law. That is the whole problem. And Your Lordship has seen many of the cases here before the Honorable Court. We have many land issues on where the national highways are being constructed. Landowners are objecting. The administration, the state is not being able to deal with it. If we follow the provisions of the National Highways Act, the Land Acquisition Act, and this instruction issued by the MORTH, none other than the department concerned, the ministry concerned, there should be no problems of land issues. So perhaps the MORTH who are here before the Honorable Court, the MORTH and the NHRE can explain why they are not following their own procedure. If this is followed, Your Lordship, all the land issues will be taken care of.
In
No problem.
in this PIL, we are concerned with a road.
Yes,
Which road?
this is the Mao Imphal Road. The Kohima Mao Road. The road to
Kohima,
Imphal. Yes.
Kohima Maur.
This road is from Rere Gate, just below the High Court over here, and extends up to the Mao Gate. This is the highway which feeds the state of Mizoram. It's a vital lifeline from Manipur. This is the lifeline for our state of Manipur, and for people who live beyond Kohima. So, Your Lordships, now there are 2 things here. Firstly, maintenance part, they are trying, as the affidavit explains. The second part is the stretch just below Pesama, the Kisama village gate. The Kisama entrance gate, the route to the Hornbill Festival, if Your Lordship has visited or not. that about a stretch of 100 meters has completely collapsed. It's not just sinking, completely collapsed. So this collapse has resulted in the existing scope of work not being sufficient to handle this new development. So that is why the NHID cell and MORTH was directed to submit an action plan on what they propose to do. So they have submitted this affidavit saying that now they propose to acquire more land. And they are saying that the proposal now will be placed before the committee, the competent authority for land acquisition. Now, who is the competent authority for land acquisition? That statement begs this question. As far as the MORTH and the NHID cell is concerned, who is the CALA here? If they follow the procedure, it should not be a problem. If they don't follow the procedure, it will lead to problems again in future, Your Lordship. So this is where we stand. The restoration plus the maintenance, it is going on. It is going on. The road is completely cut off as on today, Your Lordships. The road is completely cut off. Restoration is going on. Maintenance is going on. This stretch of 100 meters which has completely collapsed, they need to submit a concrete action plan. Expert committee report is well and good, Your Lordship. But a complete action plan on what they propose to do, that has not been placed before the zoning board. So that is the area for consideration for Your Lordships today, Your Lordship.
Yes. Okay. Yes.
What I'm representing responsible number 128. One is the service organ, then 28 NHID circle. What will be required to the query of the CAMA? All the deputy commissioners in the state, they are appointed as the competent authority for land acquisition. So they are the authorities who will disperse the amount. Once the amount is released from the ministry, the competent authority.
No, Mr. Zimomi is submitting that you have not acquired as per the act.
Whatever the proposal is made, we submit it to the deputy commissioner of each district, which is then forwarded to the state government for approval. Once it is
What
approved
proposal?
for acquisition of the land.
No, the law lays down the procedure how to acquire a land.
Yes,
You have to follow that. Who has to acquire? The deputy commissioner.
it is the deputy commissioner who has to acquire. The state has to acquire and hand it over to the concerned executing agency. Because there's also an act in the state of Nagaland.
No, you have to address us on two counts.
Yes.
First, the submission that 100-meter roads in Kisama
Yes.
has totally collapsed.
Yes.
What is your action plan for
In
this?
fact, that has to be immediately addressed.
What you propose to do?
The expert committee, they have also already visited in the month of June. They have submitted a report which I can close in my affidavit.
No, when will you restore it?
What we have also stated, we have made proposal on 3 occasions. The first occasion, we made submitted a proposal for acquiring a land.
Who will restore it? NHIDCL.
Yes,
The NHID cell is the executing agency.
Why are you not doing so?
Lordship, we are executing. We are maintaining, we are executing the process of restoration, Lordship.
When
We
it
have
collapsed,
registered
when
in
it
the-
collapsed,
Of June, you know, May, Your Lordship. May.
now what is the alternative?
The alternative was through Kisama, Your Lordship, through the Hornbill Festival site, that part. But even that alternative route is facing problems, landslides, land sinks, because of the rain.
This is the affidavit submitted by NHIDCL.
Yes, 28.
You have stated, mentioned regarding that collapsed road in this affidavit.
There is a 3 which we have stated in the affidavit paragraph 8. That is via Kisama village, Kisama. And for maintenance of that alternate road, we have released 6 crore to the state government for maintenance. Now we have also submitted a proposal on 3 occasions for embrace them.
Your Lordship, the collapse of the road is mentioned in the affidavit which is filed on 9/6/25. 9/6/25.
Because It seems that the process, the progress nature, service of the already after it will be like service of the is a program is for the estimate for then for temporary area has been received, it has been received. Immediately from the state government on 26. It's now yes.
Actually, the wages that we have taken were still at paragraph 9 of our affidavit.
The paragraph
Paragraph 9 of the affidavit.
six of the president.
Affidavit filed by respondent, but 1288.
Yes,
They really got it.
yes.
Destruction of other sites, it was.
What is Palisade crib wall? What is it? Because unless we understand the meaning,
Yes, yes. All these are technical terms for
The palisades are basically like creep walls, sir.
that I'm asking, what is it?
Sir, with bully piling, like the bully piling, sir.
I could not get you.
Sir, like wooden bullies are there. It has to be struck into the ground, and it has to be tied with the horizontal and vertical. ropes, sir.
This wall is to prevent landslide or what?
Yes, sir.
Where it is constructed?
Sir, it is
Beside the road
yes,
or
sir,
in
on the
the
slopes of the embankment, sir.
Valley side,
On the very side, sir.
on the slopes of the valley side.
For stabilizing the slopes, we constructed service.
okay. So what it will prevent further landslide or it will prevent sinking of mud.
So we're trying to construct the embankment, but in this rainy condition, it is not sustainable. So we are filling it because by the filling of geobags, sir.
Geobag means
Geobag means geomet like sir cement bags, sir. It's just like that cement bags with
you fill it with some
material and then we stack it.
what material?
Sir?
You fill it with
Sir, selected earth. It is
Okay.
selected earth so that it will not come out because of the rain, sir.
Okay. Now, yes, Mr.
We have still a lot.
No, what you do, it is how you restore the road is your duty.
Yes, Lord.
We are not going into details
Lord.
like crib wall, how you prepare, what is to be done by NHIDCL.
Lord.
You give us a timeline or you give us an action plan that within this much time we will restore the road.
Lord.
Otherwise, we will hold you responsible.
Lord.
We will not.
If court will file an affidavit, Lordship, but at the moment, Lordship.
Now, apart from filing affidavits,
Yes, Lord.
you restore the road,
Lord.
then file affidavit.
May we be allowed to file the action plan by way of an affidavit, Lord?
When?
Within a week's time, Lordship.
Okay. And regarding the second submission that you are not acquiring the land as per the procedure prescribed by the statute. You have devised your own method.
The proposal has to be submitted by the state government, Lordship. The state has to make a proposal, only then we will do.
follow up, Lordship.
So-
As per the proposal submitted by the state government, Lordship, in terms of the act, Lordship.
Yes, Mr.
Lordship, as regards to the acquisition and requisition of the land, particularly this ongoing project, that whether it's a 4-lane or 2-lane state of Nagaland, was board has issued on the general guidelines, which was already annexed with our affidavit filed on 18 June 2024, Annexure 1. That is a comprehensive guideline of land acquisition under National Act 1956. So in that guideline, clause 7, sub-clause 2 and 2, it is clearly mentioned. So as of today, we are following that way. The clause, sub-clause 2 and 2. is
Where we will find that guideline?
Page number 8 of my affidavit. Affidavit filed on 18 June 2024.
Yes.
Page number 8, the relevant portion is page number 18. Page number 18, clause 7. 7, sub-clause 2, and small clause 2 again. Page number 18.
Yes.
Sub-clause 2. Merit.
Yes.
However, considering the urgent need for minimizing litigation and ensuring early availability of land and completion of the National Highway project, land for National Highway project can be broken through direct purchase with the consent of the landowners in accordance with the existing act, rules, policies of the concerned state government. So there, Lordship, what I want to submit before Lordship is, as of today, whatever project is going on in the state of Nagaland, as of today, we are following that guideline. Policies of the concerned state.
What is the policy?
Policies are, it depends on the, in consultation with the board and state government, they adopted the policy that in that case of the damage compensation has to be given. To that
No,
policy, we
no,
have
but the 1956 Acts
yes,
provides that
yes.
for highways, central government has to acquire the land.
That's good. We don't agitate and we do not contradict with that act 1956. But this general guideline was issued under the in connection with the land acquisition under National Highway 1956, and that general guideline was issued by the board. So as of today, we are doing that way. And one thing is whether the ministry wants to acquire the land in the state of Nagaland. Actually, the concerned minister, the one who is going to undertake the development, they have to approach the state government, and we will give this logistic support. So whatever law comes, whatever provisions are there, accordingly, we will comply with that. So in this case, as and when the minister approaches us, we are ready to comply under the provision of law. But till now only today we are just recently we have received the proposal for assessment of the proposed land acquisition. Otherwise, it is a ministry to intimate or to approach the state government that such area, that particular area wants to acquire for that purpose. So in that case, we have to give the logistic support. But Lordship here, as of now, as per the general guideline issued by the ministry, we are going by that way. Otherwise, we do not contradict with the law. We are not again ignoring the provision of the law. So that's the position here.
Your Lordships may just respond to what the learned addition AG has submitted. Firstly, the submission by my learned friend that all deputy commissioners have been designated as the CALA. That is a point to be noted. Now, secondly, Your Lordship, if Your Lordship will come to that same paragraph which the learned addition AG has relied upon, 7.2. And if we may go through it again for a proper understanding. But first, with clause 1 of 7.2, there is a specific central statute for acquisition of land for the national highways. That is National Highways Act 96. As such, legally, The central government and its authorized project executing agencies are competent to acquire land for the construction, development of national highways under the NHI 1996, and the states do not have a case to insist that the land of the NH in their jurisdiction should be acquired under the statutes, policies framed by the state government's duty administration. This is just a guideline so far as how to acquire land is concerned. But the statute is very clear. Statute will prevail. Now, what is happening here, Your Lordships? What is happening in the state of Nagaland is the so-called CA, they don't pass any awards. The state decides, the state at a particular level decides that this is a compensation which should be awarded and money is.
Without there being any formal acquisition.
Formal acquisition, what's passed? That is the problem, Your Lordships. Acquisition proceedings are not initiated, therefore, we have objections from landowners every time and again. That is the problem which is yet to be addressed, Your Lordship.
Now for this road,
For that 100, yes, for that 100-meter stretch, the NHACL proposes to acquire that land, additional ROW. So we can make a start with this particular stretch. The NHACL, MORTH, as well as state must follow this. And the state is also saying, Your Lordships, the state is saying that so far, the state itself has not received any proposal from the central government about acquisition, to the acquisition proceeding. That is one part of the matter. But insofar as acquiring for national highways is concerned, it's not necessary to obtain the approval of the state or to even tell the state. Straight away, the central government can approach the CALA and the acquisition proceedings can start.
yes. Who is appearing from Union of India? Is it
That is being both for union as well as
NHIDCL?
As far as the land within the hour of this concern, there's no issue also. Now, this incident has happened in the month of May also. Now, after this, the expert committee they have put it, and it was proposal submitted by the expert committee that we need to acquire more land, which was proposed to the state government for acquisition loan. We have submitted a proposal on 3 occasions, one which has been already approved for an area of 50,000.
Under 1956 Act, which authority has to acquire land? Where is the provision? No, then you follow the statute.
In fact, in this memorandum, Your Lordships, in this guideline,
Yes.
towards the last page, I'm still going through affidavit filed by the one who named.
Which order? Just original position. Yes. Yes.
Lordship mentioned 371 articles, people just belong to the state.
Who are you?
I am represented, I am by LP from NHIDSO.
We have 2 counsel for NHIDCL. Yes, make your submission. What do you want to submit?
NHID is not applicable in the state of Nagaland. Procedure to be through the state government.
Is it?
Subject.
No, it is a very good question. It's not a correct statement. It's not a correct statement.
Yes, from where are you saying that it is not applicable?
Right, page number 26. para number 7.
Page 26 of
Affidavit. Filed by the, page number 26, madam.
yes.
Para number 7.
In page 26, there is. There is no. Which affidavit dated?
File dated 22/7. 22/8.
22/7.
22/8.
Page
26. Lord.
yes. Where?
Subpara 2. However, they consider no shift.
This has been just now read by the. This we have discussed. This you have devised a mechanism which is not recognized by the statute. What do you want to submit? Unless you make a submission, you have to say something. What do you want to say? Please say.
I say, we show more the guideline so condition, according with the existing act rules of the concerned state will be subject to above condition that the total amount of the compulsion so far will be no more than what is the payable when the land is required under the NHX 1956, which in any case in compatibility with the compression according with the provision of Act of 2013. So the state of Nagaland acquired as per the section 11 requisition Act 1965. So this is totally required in the land emergency situation.
No, that I want to understand. We want to understand that when for construction of national highways, a specific act is there, National Highways Act 1956. And when it prescribes how to acquire land for construction of national highways, why you are going to other modes of or other statutes? In the last order, Mr. Imsong, there was a direction to this state to file an affidavit regarding the status of approval and action on the proposal for the acquisition. Mr. Imsong, order dated 25/6/2025, para 6, clause 4. There was a direction to you. Have you filed an affidavit?
First of all, I have to take a further instruction. If I'm allowed to file a next date.
Action plan by next week, my lord. And state also affidavit by next week.
Okay. Heard Mr. B. Anything else you want to submit? Heard Mr. A. Zimumi, learned amicus curiae. Stop. Also heard Mr. Moa Zamir, learned counsel for respondent. Oh, sorry. You submit an action plan, what you propose to do for restoration of the collapsed road by next week. With a timeline. Action plan with the timeline when you are going to do it. What you are doing, how you are preparing crib walls or the bags, we are not much concerned about that. You have to restore the road. How you do it, it is up to you. And regarding acquisition, if additional land is required, you also,
That point.
on that point also, what you propose to do? You mention it in the, that what is the proposal, under what statute you have moved that proposal?
Very important, lordships. Under what statute?
Heard Mr. A. Zimumi, learned amicus curiae. Stop. Also heard Mr. Inti Song, learned additional AG appearing for respondent number 3 to
3, 4, 5, 6, 7, 11, and 12.
3, 4, 5, 6, 7, 11, 12. Also heard Mr. Muazzamir, learned council, learned standing council, standing council or council? Learned council appearing for respondent number 1, 2, and 8. Miss Learned amicus curiae has submitted that in pursuant to the directions of this court by order dated 25/6/2025, the NHIDCL, that is respondent number 2 and 8, have filed an affidavit he submits that though in the affidavit it is stated that an expert committee has visited Fesema sinking area on Kohima Mau Road and has submitted their report suggesting remedial measures for sinking plan. However, the NHIDCL has not submitted any action plan with timelines for restoration of the said road. He also submits that a stretch of road measuring about 100 meters at where?
Just to the Pesama village area. Pesama village area.
Fesa. That is mentioned here.
Yes.
Where?
Directly. Paragraph 3 of the opinion filed by you.
There is. Division of 5 on 9/6/25.
Yes, has been completely collapsed near Kesama exit gate under Fesama village area. However, no concrete action plan has been submitted by the NHIDCL. On this, learned counsel for NHIDCL, Mr. Muazzamir, seeks a week time to submit a concrete action plan with timelines to restore the collapsed road. Learned counsel for learned amicus curiae has also submitted that though it is stated in the affidavit by the respondent number 2 and 4 that acquisition matter has been stated here, 2 and 8, that steps are being taken to acquire required land as per the guidelines of the Ministry of Road Traffic and Highways, Road Transport and Highways, dated 28/12/2017 and 10/5/2018, respectively. However, learned amicus curiae submits that in the said guidelines, where are those guidelines?
At page 16 of the affidavit of 2 and 8. Page 16 in the affidavit of 2 and 8.
An alternative arrangement has been prescribed for acquiring the required land with a view to minimizing litigation. Learned amicus curiae submits that when the procedure for acquiring land for construction of national highways has been prescribed by the National Highways Act, same should be followed, while acquisition of land, same should be followed for acquiring any land for the purpose of construction of national highways. The learned counsel for the petitioner, learned counsel for NHIDCL is also directed to address this issue in the affidavit to be submitted next week as to how it proposed to acquire the additional land. Stop. It also appears that by order dated 25/6/2025, the state government was also directed to file an affidavit regarding the status of proposal regarding the status of the acquisition of additional land for the purpose of construction of which highway is how it is identified.
2 National Highway 2. National Highway 2.
Stretch.
Connecting Kohima to Mao.
National Highway 2 connecting Kohima to Mao. On this, learned additional AG, Mr. Inti Song, also sought 1 week time to file the affidavit in that respect. The prayer is granted. Let this matter be listed again on 20th of August. Mr. Senti Anger appears for respondent number 10. Mr. N. Muzoi appears for respondent number 13 and 14. Okay. Anybody else? List accordingly.
For admission, item number 6.
Hotel length to all temporary restoration. সেইখিনি কাৰণে restoration কাৰণে যিটো land লাগে সেইখিনি কাৰণেহে দিছে order to bottle তেওঁ submission সেইখিনি কাৰণে affect to guide দিলে
What is this?
I pray that this matter be listed next week. And
No,
in the-
why?
And in the meantime, I will place on record the order of the Indian Immediate by the ministry.
No, what is the matter?
Losses mechanically peruse the order dated 14/5/25. 14/5/25.
Yes,
If you can go directly to the paragraph which starts from in the affidavit in opposition filed by.
yes.
In the affidavit in opposition filed by the respondent number 1 on 23/4/25, in paragraph 3G, it has interiorly been stated as follows. During financial year 24/25, Ministry has initiated three-pronged action to maintain, repair, and develop National Highway 329A, including the stretch to Pimla to Mahinamse Randa. So the steps initiated. Yeah, at the bottom, however, the paragraph which starts with however, it shows.
Yes.
However, in a notice inviting tender dated 8/11/24, which is annexed 3 to the affidavit filed by the respondent number 1, the proposed stretch of the road on the National Highway 329A is only from KM 38, Santamtula near Assam border to KM 83, Pimla Junction, tentatively like 45 kilometers in the state of Nagaland. From the affidavit filed by the respondent number 1 and the NIT dated 8/11/24, it is discernible that the proposed stretch of the road from Pimla to Mainamsi is not included in the NIT, although the same is stated in the affidavit filed by the respondent number 1. So this is the issue, Lordship. By Mr. Young Ordinary CEC shall on the next date come with clear instructions as to why the stretch of road, National Highway 329A from the stretch from Pimla to Mainamsi has not been included in the notice inviting tender dated 3/11/24. This was the direction.
To this you will respond.
Lordship, I have received the order, but today I have not been print order that the union has passed an original using the set stretch of land. But today I have mistakenly I have not
This stretch has been included.
included this, but I have mistakenly.
That we will reflect.
They will produce next Wednesday. Lordship.
Okay. Okay, heard Mr. Mr.
Is long.
A. Zimumi, learned amicus curiae,
No,
appearing,
not amicus.
your petitioner, learned counsel for the petitioner. This is item number 6. Learned counsel for the petitioner. Also heard Mr. Yangarvati, learned Central Government Standing Council, Central Government Council. Mr. Appearing for respondent number 1, Mr. Joshua Sheki, learned counsel appearing for respondent number 8, Mr. Muazzamir, appearing for respondent number 6 and 7, and Mr. L.T. Sangtam, learned additional AG, appearing for the
Respondent 2, 3, 4, and
respondent number 2, 3, 4, and 5. Learned Central Government Council has submitted that as directed by this court by its order dated 14/5/2025. He has received an instruction to the effect that the stretch of road from Pimla to Mainamsi has been also included in the notice inviting tender And to that effect, the Union Ministry has passed order. He seeks some time to place the said order on record. He seeks a week's time, 1 week,
Next week.
a week's time to place the same on record. The time is granted. Let this matter be listed on 28/2025.
For admission, item number 8.
May it please your lordships. Lordship, firstly, I want to make a clarification.
Yes.
In the supplementary post case, IA criminal 22 of 2025. This IA has been filed in connection with the reservation petition. So, lordship, can we take note of that? Supplementary post, this item number 30.
We'll take it along with this,
Yes, lordship.
Albert. Item. Ekelo. What for that IA has been filed?
Lordship, by present writ petitions, I'm trying to set aside my detention order as well as a confirmation order. And during the pendency of the writ petition, my detention was extended for another 3 months. So by this IA, I'm trying to keep on record the order which I am there for another 3 months.
Then we'll allow this IA. We'll allow this IA. We'll allow you to bring on record the. First, we'll dispose of this IA. Third, you will file an amended writ petition or.
Lordship, since I have filed in the ISO.
Okay. Mr. What is your name?
Mahaka.
Mahaka, learned counsel for the applicant. Also, Mr. N. Anguli, learned Central Government Standing Council, as well as Mr. V. Zumumi, learned counsel for the learned public prosecutor, learned public or government advocate, learned government advocate. This interlocutory application has been filed by the petitioner Krishna Bahadur Chetri in connection with writ petition number 12/2025, wherein he had impugned the detention order number CON/PIT NDPS/01/2025/173 dated Kohima dated 14th July 2025. So he issued by, who issued that detention order?
The chief secretary. Chief secretary to the government of Nagaland.
Issued by the Chief Secretary to the Government of Nagaland. Learned counsel for the applicant has submitted that during the pendency of the aforesaid writ petition, the detention order of the petitioner has been extended for another 3 months by order dated, which by order dated 14 July 2025. And therefore, he seeks leave of this court to bring on record the aforesaid detention order by filing this interlocutory application. The learned counsel for the respondents learned CGSC, as well as learned Government Council appearing for respondent do not have any objection to the said bill. Therefore, this interlocutory application is allowed. The where is that detention order?
Detention order is page 25 of my petition.
No, the extension order.
Extension order is page 10.
The-
Page 10
yes,
of my petition.
the order dated 14 July 2025, which is annexed in this interlocutory application as Annexure 3, whereby the earlier detention of the petitioner was extended to another 3 months. That is with effect from 18/7/2025 till 17/10/2025 shall be treated as part of record in writ petition number WPC 12 of 2025. This interlocutory application is accordingly disposed of.
Lordship, in the meantime, the respondent may file their affidavit.
In the writ petition, you will be filing affidavit. In writ, you to সময় দিয়ে দিও। In writ petition 12, in separate order, heard Mr. N. Mogaka. How to pronounce it? Mahaka. And Mahaka. Also heard Mr. Z. N. Anguli, London Central Government Standing Council, appearing for respondent number 4, as well as Mr. V. Zimomi, London Government Council, appearing for respondent number 123. Mr. Zimomi has sought for some time for filing. No, stop. Though it is on record. The respondent number 4 has already filed its affidavit on opposition, and same is on record. Stop. However, Mr. V. Zimomi, London Council, appearing for the respondent number 1, 2, 3, seeks some more time for filing in an affidavit in opposition in this case. The time is granted. When?
2 weeks.
Let this matter be listed.
Lordship,
2 weeks.
after 1 week.
2 weeks. Let this matter be listed after 2 weeks. Otherwise, detention period will be automatically complete.
For orders, item number 9.
May I please, my lords? My lords, I am appearing online for the petitioner, my lords.
Yes. What is this?
My lords, may I brief, my lords, the matter?
Yes.
My lords, in this matter, we have challenged the order dated, this is the GST matter, my lords. We have challenged the order dated 19th of November 2024, my lords. Annexure P29.
Why it has come up in orders column? You have not filed in.
Your Lordship, there were some instructions to be received here, and I have received the instructions that as per the submission made on 10/3/2025, the department is not going to contest this case. And as per the order passed in WPC 184 of 2024,
we pray that the matter may be remanded back to the appropriate respondent authority for re-adjudication of the matter.
Okay, yes, Mr.
My lords, in similar case, Honorable Chief Justice has also taken a view.
What is the matter?
My lords, in this matter, the ITC, the input tax credit, which has been claimed by the SSC, was denied due to delay in filing of returns.
No.
Now,
I'm not getting you. Please.
my lords, the SSC, the petitioner has claimed input tax credit of
Yes,
in
that's-
its returns, in its GSTR returns, but the claim of its input tax credit was denied by the department because of delay in filing of returns. Now the government has amended the provisions and brought in new provision by way of section 16(5) in 2024, my lords, at by way of notification at P28. And by that notification, the ITC, which was earlier denied, is now allowed. And my lords, the Honorable Chief Justice, but in the similar matter of the petitioner itself, has allowed and remanded back the matter to the adjudicating authority. My lord.
By which order? This order.
My lords, my friend is carrying a compilation, and in that compilation, at page 4, my lords, it is starting from page 4, my lords. It is the order of this honorable court itself.
But they have that this is for so similar. It are going into case. What is your name?
Ketan Jain, my lords.
Heard Mr. K. Jain, learned counsel for the petitioner. Also heard Mr. Z. Kulnu, learned counsel for the respondent. You are also challenging here the quashing and setting aside of the notification dated 31/3.
We are not pressing on the notification, my lords. We are only challenging, as of now, the order dated 19th/11/2024. It is annexure P29, my lords.
This writ petition under Article 226 of the Constitution of India has been filed by the petitioner, namely Messrs. ITI Limited, impugning the order dated
19th,
Which order?
19th November 2024, my lords. It is annexure 29.
Yes. Order dated 19/11/2024. Where is that order? Page?
Page, it starts from, my lords, page 365.
Who is the issuing authority?
Issuing authority is Additional Commissioner, my lords, respondent number 7.
Order dated 19/11/2024. Passed by Additional Commissioner Dimapur, CGST Division, whereby what demand was levied?
My lords, the demand has been inter alia levied on account of violation of section 16(4).
Page 4.
My lords may also refer to the order passed by this honorable court on in another matter, in similar matter of this petitioner only, my lords.
We'll go to that first.
Okay, my lord. My lords, on page 369, my lords may see the demand has been levied on behalf of this violation of section 16(4).
369, which?
369 serial number 2. My lords, just under the table on the page 369.
Yes, 369.
My lords, in the last 5 lines, may I read, my lords? In
Yes.
the instant case.
Which line you are reading?
Last first 1, 2, 3, 4, 5, 6, 7. Last 7th line, my lords.
Yes.
In the instant case.
Yes, please.
In the instant case, the taxpayer noticee has filed GSTR 3B returns for the period from July 17 to March 18 on 14th of December 29 together, which is beyond 20th April 2019, thus forfeited the facility to avail such ITC of 2017-18 forever. Therefore, the ITC amount of so and so 1 crore rupee 8,79,920 only for the period July 17 to March 18 is not admissible to them, and the details are subscribed in the format below. My lords, in this, what has happened is we have, due to the delay in filing of return, they have disallowed our ITC, input tax credit. Now, by way of amendment, the government has introduced section 16(5), my lords. My lords, may I take my lords to that amendment also?
Yes.
My
No,
lords,
you will not allowed to avail this input tax credit of 1 crore
8 lakh and odds, my lords.
by the impugn order.
Yes, my lords.
And what is your submission?
My lords, the law has now been amended. Another provision has been introduced by the government by way of this notification, my lords, by way of Finance Act, and which has been implemented by notification. The amendment is at Annexure 27, my lords. The annexure starts at page number 359.
Section 16(5).
Yes.
So your submission in the earlier writ petition number 27/5/2025 remains same in this writ petition also.
Yes, my lords. Earlier number was 184 of 2024, my lords. This is 27 of 2025.
Earlier, which is the order? Order dated?
The order of the Honorable Chief Justice is of dated 17th of February 2025, my lords.
Where is that?
In the compilation, my friend must have handed over to the bench, my lords.
Yes.
It is at page number, it starts at page number 4. May I read, my lords?
Yes, please read.
My lords, in the second paragraph on page 5, my lords, I am reading the relevant part, my lords. It is submitted by the learned counsel for the petitioner that with the insertion of section 16(5), subsection 5 in section 16 of CGST Act by way of Finance Act, the grievance of the petitioner regarding availment of IT input tax credit is more or less resolved. However, it is submitted that the impugned order in respect of certain other Demands have been passed without providing opportunity of hearing to the petitioner.
We will do this. Okay.
Now I am reading the next paragraph, my lords. Learned counsel appearing for the respondent also submitted that he is already in receipt of the instructions from the department that the matter may be remitted back to the authority concerned for deciding the issue afresh in accordance with the provisions of the CGST Act, including the new amendment introduced in section 16(5) of the CGST Act. In view of the above submissions made by the learned counsel appearing for the parties, the impugned order dated 27 December 23, passed by the respondent number 7 is set aside. The matter is remitted to the
What was
respondent
the
number
last
7.
line? What was the last line?
The matter is remitted to respondent number 7 to decide the matter afresh in accordance with the provision of section 16 of the CGST Act as
Mr.
amended.
Jain. Yes, what was the last line? No,
la-
not to you, Mr. Counsel.
Okay, sorry.
Division, stop. Then you quote para 2 from order dated 17/2/2025. It is here in the record. I'm flagging it. 17/2/2025, passed in WPC number 184/2024. Quote para 2. Quote para 3. Quote para 4. Instead of order dated 27/12/2023 in para 4, mention the order impugned in this case. Order which has been impugned in this case. Okay, we are setting aside the impugned order and remanding the matter back to respondent number 8.
7, my lords.
Respondent number 7. This writ petition is accordingly disposed of.
Highly obliged, my lords.
Okay.
Now, one submission. Oh no, it is covered. Nothing is repeated.
First question.
Highly obliged.
For orders, item number 10.
Lordships, I have instruction to appear for the number 1.
In the IA. Who is
In the IA.
May I please, your lordships?
This
I'm
IA.
appearing for the appeal.
Objection to the IA.
Okay.
Find my power as well. I have a
Heard Mr. V. Devnath, learned counsel for the applicant appearing through video conferencing. Also heard Mr. P. Foseco Forte, who submits that he has been instructed by respondent number 2.
1.
To appear in this case. However, he seeks some time to file the Vakalatnama as well as to file written objection against the prayer for condonation of delay made by the applicant. The prayer is allowed. Let this matter be listed after
3 weeks, my lords.
after 2 weeks. After 2 weeks.
Highly obliged.
Highly obliged.
For orders, item number 11.
May I please, my lord, this is an appeal preferred by the Union of India through which agency Central Institute of Horticulture. My lord, this is a department under the Ministry of Agriculture and Farmers Welfare. Now, my lord, by way of this appeal, basically we are challenging And
You are
includes
paying, you are paying for condonation of delay.
Yes, my lord.
We will issue notice.
Deeply obliged, my lord. Notice will be issued.
Heard Mr. B. Deka, learned counsel for the applicant. This application under Section 5 of the Limitation Act 1963 has been filed by the applicant for condoning the delay of
190.
199 days in preferring the connected appeal. Stop. Issue notice to the respondents. Sole respondent.
No, my lord, this is the sole respondent. He used to be the lead petitioner.
Issue notice to the respondent. The petitioner, the applicants shall take steps for issuance of notice upon the respondent by registered post with AD as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks. Placed accordingly.
My lord, item number 12 is similar. The vote is read appeal arise out of the common judgment and order dated, order passed by the same bench judge.
Item number 12 was
Yes, yes, ma'am.
delays of
Yes, ma'am.
same.
Yes, ma'am. There is also a
199.
delay of 199 days, ma'am.
Okay. Same order.
So
Same
similar
order.
order may be passed in this appeal as well.
Item number 12, same order.
Deeply obliged.
Orders, item number 13.
Yes. Mr. Anguli, you are appearing as counsel.
Council, yes.
Okay. What is this delay condonation?
My lord, I'm respondent, my lord.
Oh, yes. You have, who is for the applicant? You have objection?
Yes, my lord, but I have not received any.
Okay. None has appeared for the applicant on call. Mr. N. Anguli, Z Anguli, learned Central Government Standing Council, appears for respondent number.
All respondents.
All the respondents, appears for all the respondents. This application under Section 5 of the Limitation Act 1963 has been filed by the petition applicant Sachin Kumar Thakur, praying for condoning the delay of 490 days in preferring the connected writ appeal. Issue notice to the issue notice. Since Mr. Z. Anguli has appeared for all the respondent, no formal notice need to be issued. However, the petitioner is directed to furnish the copy of application for condonation of delay along with the memo of writ appeal and annexures to the learned counsel for the respondent within the petition is within 7 days from the date of this order. The learned Central Government Standing Council also submits that the respondents would be filing written objection against the prayer for condonation of delay made by the petitioner and sought some time for the same. The prayer is.
My lord, since I have not received any brief of the IEA as well as that.
No, if they don't, we will fixing it after a month. Within 7 days, the applicant is directed. If he does not comply, then consequential orders will be passed. List this matter after 4 weeks.
Orders, item number 14.
Yes, Mr. Zimomi.
About the first IA issue. I know what that is. IA 130 is the application for leave to appeal. The application which shall be filed under chapter 5, rule 76D of the Gauhati High Court ruling. I will hear a party in writ proceedings.
But you are effective.
Yes, my lords. So there is one vacant post, a regular vacancy in the writ proceedings. Now, under the circumstances, it appears that both the petitioner as well as the private respondent who had the dispute, they were applying for appointments basically through the back door. So one of them succeeded. The respondent number one in this opposite party one succeeded. The respondent.
Then we'll issue notice.
For the leave to appeal, your lordship, that is up to your lordship discretion. There's a delay application which is IA 129. So the application for leave to appeal, that is at your lordship discretion.
First, which way? Which shall have to be taken first?
The leave to appeal. The leave to appeal, which is 130 of 2025. Application for leave to appeal.
But whether for granting leave
Yes, my lords.
to appeal, opposite parties are required to
No,
be
not
heard.
required, your lordships. Is tally up to your lordship discretion at the time of ruling.
Where is the provision?
What your High Court rules, your lordship.
Yes, let us go through them. Two copies, one to bar. Give one copy to, give it to bar. Yep. Give this one there.
I have a copy, but I must get it for Chapter 5, your lordship.
Till it arrives, you take it and read it. We'll hear you. I am on question that while granting leave to appeal,
Yes, ma'am.
whether the opposite parties are required to be heard or not,
My lord, yes,
whether they deserve a notice.
my lord. Page 53, chapter 5.
Yes.
Rule 76, my lord. Rule 76, chapter 5. Whenever by a decree or order which is applicable to the High Court, the interest of D, the person whose interest arose after the date of such decree or order by reason of any creation or dissolution of interest by, to, or from any part to such decree or order is effective, and such beneficiary legal representative, assigning a person who was not or has not been made a party to such decree or order or to proceedings thereunder or thereof and desires to appeal therefrom. Where he may name himself in a memorandum of appeal as an appellant, along with such memorandum of appeal, he presents an application for leave to make himself an appellant and an affidavit stating such facts as may be necessary to support this application.
Huh? Where is the requirement of leave?
Your Lordship. Your Lordship, if Your Lordship can see the reduction of Rule 76. Whenever by a decree or order by which is applicable to the High Court, the interest of a person whose interest arose after the date of such decree or order by reason of any creation or devolution of interest by, to, or from any prompt to such decree or order is effective. And such beneficiary, the executor, assignee, or person was not or has not been made a part in such decree or order or to proceedings thereon or thereon and desires to appeal therefrom. He may name himself in a memorandum of appeal as an appellate. If allowed, with such memorandum of appeal, he presents an application for leave to make himself an appellate.
Okay.
Because he has made opposite parties. The opposite party has been whether they have notices to me. They may have a social development.
Yes. If notice is not required, why have you made them opposite parties?
If it is
Just a matter of form, my lord.
No, I am on question of law.
That is why, Your Lordship, a matter of form, since they were parties in direct petition. Just a matter of form, my lord.
into the petition possible. Petition possible. You will be affected. I think you can be subject to delay confirmation. Delay confirmation of not available. You can trade it. But if you are sick, you will be able to offer.
Heard. Mr. Z. Dimumi. Mr. A. Zimumi, learned counsel for the applicant. This application under Rule 76 within bracket D of the Chapter 5 of Gauhati High Court rules have been made by the petitioner, by the applicant, namely C. Alim Sangtan.
No, my lord, it's the, you go to a petition with the applicant.
Where you have not named him. Oh, yes. Namely, Vigoto Chishi, seeking leave to prefer an appeal against judgment and order dated 5/5/2025, passed in writ petition number 193/2021. Learned counsel for the applicant has submitted that the petitioner was not made a party in the said writ petition. However, he has been affected by the impugned order and therefore he seeks leave to prefer the connected appeal. Stop. Considering the grounds stated in the application for seeking leave to file an appeal as stated herein above, we hereby dispense with the notice to the opposite parties and grant the leave which has been sought for, subject to the law of limitation. This interlocutory application is accordingly disposed of. In IA
the 9 days of delay.
Notice will go. Heard Mr. A. Zimomi, learned. Learned counsel for the applicant. Mr. Zamir, Mr. Imchen, you are appearing for?
1, 2, and 3.
Also, Mr. on 4.
You would train for.
Also, Mr. Moaim Chen, learned senior government counsel, appearing for respondent number 2, 3, and 4. This application under section 5 of the Limitation Act 1963 has been preferred by the petitioner, Mr. Vigoto Chishi, praying for condoning the delay of 35 days in preferring the connected writ appeal, whereby he has impugned the order dated 5/5/2025 passed in WPC number 193/2023. Issue notice to the respondents. Since Mr. Moaim Chen, learned senior government counsel, has appeared for respondent number 2, 3, and 4, no formal notice need to be issued to the said respondents. However, as regards respondent number 1 and 5, the petitioner shall take steps for issuance of notice upon the said respondents by registered post with AD as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks. You have received the copy of application. List accordingly.
For orders, item number 15.
Yes.
Please, my lordships. Lordships, I have, IA 131 is for condemnation of 12 days. Otherwise, if computed from the date of receiving the judgment order is 8 days in filing the main rate.
Who is for the other side?
Your Lordship, I have instructions to appear on behalf of the private respondent number 5.
You will be opposing?
So as far as the delay confirmation is concerned, I would not object, but my Lord, I'm entering appearance today. I will be filing my power
Oh, you have not filed yet,
Yes, Your Lordship.
Vakalatnama.
by tomorrow.
Then we'll list it on 20th, next Wednesday.
Lordship, I have a matter in principal bench.
Oh. Because he has not yet filed his Vakalatnama. Otherwise, we would have reflected his submission and granted this. What do you suggest? We'll issue notice. We'll issue notice.
Issue notice.
He may appear in the meanwhile. Heard Miss Z. Zimumi, learned counsel for the applicant. Also Miss Pichano, learned government counsel, appearing for respondent number 1, 2, 3, and 4. Stop. Mr. Joshua Sheki has appeared and has submitted that he has been instructed by respondent number 5 to appear in this case. However, he seeks some time to file his Vakalatnama. Considering the issue notice, since Miss Pichano, London's government counsel, has appeared for for respondent number 1, 2, 3, and 4, no formal notice need to be issued to the petitioner and to the said respondents. Stop. Further, in view of the submissions made by Shri Joshua Seki that he would be filing Vakalatnama on behalf of respondent number 5 within
Lordship.
2 days from the date of this order. The petitioner,
About listing the matter on 20,
just that what is I am suggesting.
Lordship. I was,
No. What is the last line? Last word. Hence, no formal notice need to be taken against respondent number 5 also. Let this matter be listed. No, how?
on
On
20,
28, 2008,
Yes.
2025.
Objection.
Orders, item number 16.
Yes,
Their place of options. There is a delay of 5 days in filing the writ appeal.
5 days.
I have mentioned in paragraph 5 and 6 of the condonation application.
Will issue notice. Third, Mr. C.T. Zamir, learned senior counsel, assisted by Miss
Imtila.
Imtila Pongen, learned counsel for the applicant. This application under Section 5 of the Limitation Act has been filed by the petitioner, Ms. Atwa Meru, seeking condonation of delay of 5 days in preferring the connected writ appeal. Stop. Issue notice to the respondents. Ms. Pichano appears for Ms. Pichano, learned government counsel, appears for respondent number 1, 3, 1 and 3.
Lordship, in respect of respondent number 2, I may be allowed to take steps by registered post as well as custody service because it is an election matter. Time is essence here.
Okay.
In case if the parties do not respond, then
Okay.
there will be further delay.
Issue
And
no,
this sort of matter is to be disposed of within a time-bound manner. Lordship.
issue no. The petitioner shall, however, take steps for issuance of notice upon respondent number 2 as well as respondent number 4 by registered post with AD as well as by usual mode.
Justice.
By usual mode. The petitioner is also allowed to take steps for issuance of notice by dusty mode on respondent number 2. After effecting service on respondent number 2 by way of dusty mode, the petitioner shall submit an affidavit in compliance to that effect. Let this matter be listed after
3 weeks.
3 weeks.
Highly advised, Lordship.
For orders, item number 17. This Lordship.
My lord, in this case also, there is a delay of 5 days if we include the holidays. Lordship,
Otherwise,
Lordship, the judgment was delivered, every judgment was delivered on 26th of June.
we'll issue notice.
Lordship.
Heard Mr. Takamasha, learned senior counsel, assisted by Mr. Haringlong, Mr. Sentilong, learned counsel for the applicant. Also heard Ms. Pichano, learned government advocate, appearing for respondent number 2. This application under Section 5 of the Limitation Act has been filed by the petitioner
In paragraph 3, it is mentioned, Lordship.
Temjin Younger Jamir, praying for condonation of delay of how many days?
5 days.
5 days in preferring the connected writ appeal, wherein he intend to impugn the judgment and order dated 26/6/2025, passed in WPC number 98/2023. Stop. Issue notice to the respondents. Since Ms. Pichano Learned Government Council has appeared for respondent number 2 and 3 also, no, only 2. Only 2. No formal notice need to be issued to said respondent. However, as regards respondent number 1 and 3, the petitioner shall take steps for issuance of notice by registered post with AD as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks. List after 3 weeks, list accordingly.
From the supplementary causes for orders, item number 27.
Lordships. My lord, this matter has been referred to me by the Nagaland State Living Services Authority. This is an appeal against the conviction in the Poxso case. And I'm challenging the order dated.
Poxso.
29/5.
If it is Poxso, notice will go to the.
Yes, Lord. My lords.
Heard Mr. Joshua Sheki,
Yes, Lord.
Learned Counsel for the applicant, also heard Ms. S. Mere, Learned Public Prosecutor. This application under Section 5 of the Limitation Act has been preferred by the applicant/appellant for condoning the delay of 235 days in preferring the connected appeal, connected criminal appeal against judgment dated 29/5/2024 and order dated judgment and order dated 29/5/2024 passed by Learned Special Judge Poxso, Dimapur, whereby the petitioner was convicted under section 376 within bracket 3/354 of the Indian Penal Code, read with section 4 and 8 of the Poxso Act, and was sentenced accordingly. Stop. Issue notice to respondent number 2. Since Ms. S. Mere has already appeared for respondent number 1, no formal notice need to be issued to respondent number 1. As regards respondent number 2 is concerned, the petitioner shall take steps for issuance of notice upon the said respondent in pursuant to the prevailing notification of the registry in this regard. Returnable on after 4 weeks,
My lord.
after 3 weeks,
Your lord.
list accordingly.
Bless you, Lord.
For hearing, item number 22.
Yes, my lord.
Yes.
Here the states the appellant.
State is the appellant.
Yes. States aggrieved by the
order and judgment dated 26/4/2022, passing with petition number 329/2021, Worship.
Where is the impugned judgment?
Judgments. Page 74. Pretty part is page 80.
Yes, what is the method?
Here. uh, Here the direction given is in view of page 18 of paragraph 6, in view
Yes.
of what has been stated above, that this court is of the considered view that petitioner deserves regularization of her service so that she would be entitled to enjoy pension and pensionary benefit. Therefore, the impugned note given under UO number 207 by the additional senso on 18/7/2020 reproduced here above. Senso is quashed and set aside, and the respondents are directed to regularize the service of the petitioner within a period of 3 months from the date of the receipt of the copy of this order, so that she would be entitled to get her pension and pensionary benefits. The first point of contention of ground is the UO note, which is an interdepartmental communication, should not have been quashed. That is, and that is interfere with lordship. That is one point. And now there are two office memorandum for regularization of work charge to casual employees. One is OM dated 22/9/2004. Then another one is another one is 17.
In the year 15.
Yes, 2015. Now, in any of the two memorandums, the petitioner was applicable to be absorbed or accommodated. Whereas the learned single judges without give a kind of like blanket order by quashing the UO note.
No, what was the reasoning in the impugned order?
I'll take my notes to paragraph 5. There's some detailed discussion.
Para 5 of the
Just
impugned order,
yes,
impugned
page
judgment.
7.
Yes,
May I read?
yes.
On careful perusal of the direction given by the learned single judge in the WPC Senso, the operative portion of which has been already reproduced herein above, it can easily be made out that the direction to consider the representation of the petitioner in terms of the office memorandum dated 22/9/2024 and 17/3/2015 was given consciously because the petitioner was in service in 2004, having been appointed in 1987 and still continuing in service. In 2004, the petitioner had completed 16 years, 18 months, and she was very much eligible to be considered as per the office memorandum dated 22/9/2004, where no qualifying length of service was prescribed. That is one aspect. Therefore, she could have been considered even at the time. The fact that she was not considered is not her fault. It is keeping in view that the learned single judge had directed the respondents to consider her case in terms of the OM dated 22/9/2004. Having not done so, the respondents cannot do away with her case by saying that she was not eligible in terms of the office memorandum dated 17/3/2015. Besides, as stated in the judgment cited by the learned counsel for the petitioner, a person who has continuously worked for such land of service cannot be led to go empty-handed at an age when she has very little chance of getting re-employment. The petitioner has spent, as stated above, the best part of her life in giving service to the state. Therefore, it would be inhuman to send her empty-handed after all these years of service. The state, being a model employer, cannot do such a thing to its own citizens. In cantonal cases, directions have been given by this court for regularization of similarly situated ones, and one of them is in the common judgment of order dated so and so passing so and so. The relevant portion of the judgment is as follows. It is true that the petitioners served as work judge laborers, and they continued their services, though they were never regularized. But it must not be forgotten that for people who serve in that kind of employment with such wages, salary, it is not by choice, but by compulsion of means. Therefore, the welfare state, instead of taking advantage of the compelling circumstances they are in, should have taken up measures for providing better conditions of service and should also have regularized their services. To do so would have been most just, equitable, and reasonable. After all, their services have been utilized for the best part of their lives. However, the state government chose not to take any action to alleviate the service conditions of the petitioners. Right to life is provided in Article 21 of the Constitution of India has been interpreted as life with dignity, not mere existence. The government in a welfare state is duty bound to take care of the welfare of its citizens and not exploit them. Slavery or bonded labor are things of the past of the same country had attained independence, but it appears that in this state, the same has continued to exist, though it may be under different names. The state ought to have played a model role as an employer so that other employers who are non-state bodies or individuals may follow and treat the citizens of the state with dignity. It is time the state wakes up to its calling. At the cost of repetition, I may again state here that the petitioners have served the state with the best part of their lives, and with so much sacrifice. Therefore, it is time the state should come forth and at least give them pensionary benefits so that they do not suffer from penury and continue to live in want for the rest of their lives. There are, after all, not only citizens of this state, but they have also given the best part of their lives for the state. In view of what has been stated above, this court is of the view that the state represented by the respondents should consider the case of the petitioner for regularization of their services for the purpose of pension and pensionary benefits. Accordingly, the respondents are hereby directed to initiate the process and complete the same within the period of 4 months from the date of the receipt of copy of this order. That is, make references in the last paragraph have been referred to. So this was also allowed mainly on humane consideration, Lordship, as the order is clearly reflected. Now, not only that, again, the learned single judges also make a reference to state of Manipur and others. Others reported in 1997 to GLT. That is page 77. To GLT 209 to 77.
Yes.
Here, the judgment says that person serving for 29 years should not go empty-handed. Simple. That is the simple, my lord knows. So there was also make a reference to this points, Lordship. So on the basis of this, the EO notes was quashed before even the
What is there in the EO note?
EO note was against against the petitioner.
How he was not found qualified under 2004 and 2003?
Yes. No, that was what. According to the state, he is not qualified.
Why? Why?
Because his seniority has not yet attained.
Okay, he was
So-
not senior most.
Yes, the senior most. Then there was a merit coming, but she was not even the senior most in her own division. Forget about the entire state, Nagaland. And again, coming back to 2015 memorandum, there were 3 and 3 points. In 2 categories, she could have been eligible, but one category is she should attend 30 years of service, which my lord knows. But she was short of 4 months, after 24 months and 21 days. So technically, again, it became impossible. Then again, in continuation to 2004 ratio, in 2004, there was 50-50 ratio, direct recruitment and working for the department. Again, that was enhanced to 70%. But again, that also she's not reaching. So on the verge of her retirement, she could not be accommodated. So that is the technical difficulties the department face. How much department would like to accommodate her? Because again, if by following this blanket order, if she's allowed to be regularized, then it's going to opening up a floodgate. And one thing is,
Petition, the appellant is the respondent is a lady.
yes, she's a lady, yes.
Okay, how many years she rendered her services?
29 years, 4 months, 21 days, yes. And one thing is, again, another thing is she was neither holding sanction post nor any substantive post, though she was enjoying skill of fellowship. So if I may take my lords to my the ground appeals page 12, if I may be allowed to go, it looks for 5 pages, the word is not big, so you'll be able to clearly present what I would be states the stand of the position.
Yes.
B, ground appeals, B. Page 12, my definition.
Page 12.
Yes. Different views from page 11, but that's
Yes.
B. Let me start from B, my lords. For that, the petitioner as a work charge employee was neither holding a substantive post nor essential post. C. For that, the learned single judge has failed to fully grasp, comprehend, and appreciate the scheme provided in the OM 1705-2015 on the following counts. Okay. The mechanism provided by OM dated 22/9/2004 has not been effective enough to absorb the presence of work charge and casual employees in large scale under various departments in Nagaland into regular cadre. Therefore, for the primary reason to address this issue, the OM dated 17/3/2015 is brought out by the government in compliance with the direction passed by this honorable court in WPC number 99/2009. The OM 17/3/2015 has opened up 3 entry points made available for regularization and absorption of the service of the work charge and casual employees who are enjoying the scale of pay. They are 1 at par 1 of OM dated 17/3/2015, all existing work charge employees of various departments who are enjoying scale of pay and have completed 30 years or more in continuous service as on 1/1/2015 are eligible to avail this scheme. This scheme, anyway, this is not applicable directly, not applicable to the also qualified under this. Then 2, at paragraph 1, Problem 2 of OM dated 17/3/2025, those work charge employees in scale pay will have completed or will complete 30 years in continuous service after during the 5 years period from after 1/1/2015 till 31 2019 are eligible to avail the scheme. However, the petitioner has neither attained 30 years in continuous service as on 01/01/2015, nor could attain 30 years in continuous service to avail the benefit of 5 years window period when she retired on 31/3/2017, as she had to be released from service after serving 29 years, 4 months, 21 days on superannuation pension. 3. At paragraph 1(3) of the OM dated 17/3/2015, the OM dated 22/9/2004, which provided a scheme for regularization of work charge employees against 50% of all vacancies of similar nature in the departments on the basis of seniority come merit by giving preference to the senior most in the category is modified by para 1 Provision 3 of OM dated 2015, enhancing the quota for work charge employees from 50% to 67% for 5 years effective from 01/01/2015 and expired on 31/12/2019. And therefore, OM dated 17/3/2015 was called in the field when the petitioner was released with effect on 31/3/2015 after 29 years, 4 months, and 21 days in service. However, as per the work charge seniority list of sweeper under the executive engineer PWD Mokuchun Division 2015-2016, it appears the petitioner was not the senior most work charge employed in the department to avail the benefit of service regularization even under this scheme provided in para 1(3) of the OM dated 2015, when she was released from service with effect from so date. Despite the fact that the petitioner is not qualified to avail any of the entry points indicated above, the learned single justice erred in directing the government to regularize the service of the read petitioner for pensioner representative or such direction is tantamount to directing the government to debate on intent and purpose of the policy laid down by the OM dated 2015 and act against procedure in place.
Tell me, when did you have this additional affidavit
Yes,
filed on 12th of December 2024?
yes, yes, sir.
Stand taken is that persons who were junior to him.
Yes,
Have you responded to it,
yes.
or would you like to respond to it?
This,
You see, people junior to him have been regularized.
yes.
Is it not unfair not to allow?
That's the worship, that is also their worship. But again, just on the basis of this, the direction of the honorable single judge, blanket by blanket, without given us some sort of navigated, let's say, department to regularize just blanket like this is opening up.
No, not a single judge. The persons junior to him were regularized,
Yes,
leaving him out.
yes.
That fact was not before the not a single judge fine.
That was
You
not
did
the-
not have given your argument that there should not have been a blanket order directing the state to regularizing. There should have been some leverage given to you. But now that before us in appeal,
Yes, yes,
this fact has come up that people who were junior to him have been regularized.
yes. Okay. So,
I think
since my lord knows better that since you all know it should not have been interfered with.
what is the full form of UO?
Worship.
What is the full form of UO? You are saying it is a
You all
UO.
know that's interdepartmental communications. PNR has expressed its opinion in office notings, and that is supposed to reach before it reach the nodal department. This is PWD. The notice that was brought before this court, and that was washed before the UO note. The office noting attains its finality.
No, what is the full form of UO?
Or unofficial noting, something like that. So, and that is a settled position law that is should not be interfered. So, my lord, Since my lord has already pointed about the additional.
Even if we agree that the said office, UO note should not have been interfered with. Even then, the prayer that she should have been considered for regularization or at least regularized
So my lord, if
under other circumstances.
other circumstances, except for the additional affidavit.
Yes.
That is before my lords.
Writ appeal is a continuation of the writ petition.
Yeah.
We can take up everything.
Yes, so my, I'm before my suggestion, maybe if I can assist, if the single, the impugn notice squash and send back to the department and let the department. When the UO note reach the department has to take a decision on it. So if they may be directed to take the decision along with the addition,
When did the person retire?
Okay,
When did the person retire?
2017.
It is 8 years down the line. If we
Yes.
still allow you to take a decision, goes against. Fine is
Also, because one thing is, again, if we, this overlook the UO note, then again, in some other cases, if this prisoners to get.
no, we agree to overlook the UO note, but then tell us why she was not entitled to regularization when her juniors have been regularized. You have a scheme for regularization.
I have not, I've, after finding of that additional affidavit, I've communicated to the department, I've received no, no comment.
You have
to that
received
effect.
no comments.
Yeah.
Okay.
The later which we can next in the additional affidavit.
No, you have one hurdle to cross. You have still one hurdle to cross. See, those people who were in service when they completed 30 years of service and they were in service on that day, those juniors, it appears, have been regularized. Your client retired before she could attain those 30 years. So there is a difference in your position. Had you completed 30 years of service and any of your juniors had been regularized, the situation would be different. But here you never completed the 30 years.
Yes, Lordship. The petitioner has not completed 30 years. Lordship, the date of regularization of the juniors. Lordship, if you see the, Lordship, kindly see the page number 8 in my affidavit.
Yes.
Lordship, if you see the date of regularization of the juniors.
Yes.
Lordship, the junior, this is serial number 3, page number 8. Ushili Aomi. She was regularized in the year 2004.
Serial number?
Serial number 3. Ushili Aomi.
Yes.
She was appointed in the year 1999.
Yes.
And she was regularized on 31/2004. And another ship is serial number 6. She was appointed in the year 1996. And she was regularized in the year 2011.
You were appointed in the year, what year?
I was appointed in the year 1987.
87. So in that case, if we go by your arguments, 1, 2, everybody is appointed after you. 1, 2, 3. 1 is also 1991 after you.
That's what the person figuring is serial number 3, 6, 7, 8.
No, why not 1? Acha, you are a khalasi, I'm so.
No, the petition was serving as a sweeper.
Sweeper, show me one sweeper, yes.
We see the
Serial
sweeper.
number 10.
Serial number 10.
10.
She was this person was appointed in the year 1996. I was appointed in the year 1987. Then she was regularized in the year 2012. And in case of sweeper, again, serial number 27. She was appointed in the year 2007. And she was regularized in the year 2012.
Let's go say, it is also appointment, appointment is also to 180. It was 99. particular type regularized করে দিল এই appointment for 87 ক্ষেত্রে আগতে হ'ব 30 বছৰ কমসে কম 99 ৰ জন appointed তাতকে তো আগতে 30 বছৰ হ'ব লাগিব বিনা 30 বছৰতে এটা কৰিছে কিন্তু regularization 30 বছৰ লাগিব seniority can be touched anyway. Please listen, Marlon. Seniority is seniority acting command. যদি 18 যদি কেউ যদি she has to be senior to 99. 2009, 2019, আগতে রেগুলারাইজ করে তুলি from this after the person appointed she must take this things ঘটনা তো পেলে যে যদি 30 বছর মধ্যে হেল্প করেছে এটা হলো ইলিগাল এটা ফসলি যদি ভিডিও কোন যেটা if you want to reply on the 20th you can keep it part of if you don't have a release on all of that what it's supposed to do and you choose the query function this query because 2015 গোটে কইছি 2015 এর 30 বছর হয়ে গেল 2004 to 30 বছর তো মাসিল yes এটা ভালো লাগিছে it was not what we can do is this since it's already time what we can do is this we can have it listed again on 20th subject to what my senior brother says we'll have it listed on 20th you try and have whatever instructions you can have on this affidavit because this will be very crucial for if you go through the earlier order passed by my order Justice Vishnu on just read that order yes 15/12/2024 if you read that order if you see para 4 prima facie we are of the view that the judgment passed by the learned single judge is not liable to be sustained your arguments to some extent were accepted. However, the learned counsel for the respondent has submitted that the persons engaged as work charge employee after the engagement of the respondent have already been regularized. This amounts to violation of Article 14. So unless you answer this additional affidavit which has been filed pursuant to this order, otherwise what has come from the state perhaps is what the law is. Okay. When we talk of Article 14, so
Heard Mr. K.V. Angami, learned counsel for the learned senior government counsel appearing for the appellant. Also heard Mr. Limao Pang, learned counsel for the sole respondent. Learned senior government advocate counsel for the appellant submits that though he sought instructions as regards the reply to affidavit in opposition filed by the petitioner as regards to the as regards to the contentions raised in the additional affidavit filed by the petitioner, he is yet to receive a response. Since one of the plea taken by the sole respondent in his additional affidavit that some of the work charged employees who were appointed after the appointment of the present, after the appointment of the sole respondent were also regularized after the appointment of the sole respondent and who were junior to him, junior to her, were also regularized. the learned single judge rightly passed the order of regularization, keeping in view the spirit of Article 14 of the Constitution of India. He therefore submits that no, we are therefore of the considered opinion that the appellant may be granted some time to seek instructions regarding this aspect. Accordingly, we keep this hearing part heard and fix this matter again on 28, 2025.
For motion, item number 1.
May I please, your lordship?
Yes.
But in this case, lordship, the petitioner was arrested on 16/6/2025. Today he has completed 59 days, lordship.
You have annexed the bail application of co-accused, any of the co-accused?
Yesterday, lordship, I had referred to lordship. That is BA number 2460 of 25.
DA number
2460
60.
25.
विषय के निकाल पाओगे ना?
Order dated 5/8/2025, my lord.
Order dated
5/8/25.
Yes, Mr. Bosho.
My lord, here, my lord, my lord, can this stated that my lord, this is 59 days today, my lord. I have communicated, my lord, right, my lord, they will send the city, but till now we are not receiving, my lord.
But the offense is 60 days offense.
Offense is 60 days, my lord. That's true, my lord. And CS not fine, my lord. Till date CS not fine.
So we are granting bail on the same terms
My lord.
Yes, lord.
of the co-accused.
Only my submission may be recorded because my lord, the offense is serious in lesser and my lord, from the
Okay.
that part may be recorded.
I'll pass orders in chambers
My lord,
after going through this bail order.
my lord.
Okay. Bail is allowed, but the amount would remain same as it was for the co-accused.
30,000 was there.
30,000 with one surety of like.
Yes, lordship. Highly applies.
For motion, item number 2.
May I please, your lordship? Lordship, this item, this bail application is analog matter with item number 1, lordship. I have completed 58 days today, lordship.
Who are you?
I am Rina Brahmo, lordship. The analog matter with item 1, lordship, is CIDPS case number 4. I have completed 58 days, lordship.
What is the date of your detention?
17/6/2005, lordship.
Yes, Mr. Bosho.
You can, my lord, the same way, my lord.
Same order.
My lord, no, my lord, it is also 58 days. Otherwise, my lord, city is not available with us.
We are allowing
My lord,
on the same terms.
CS not fine, my lord. That's true, my lord. Otherwise, 60 days offense, my lord. City, my lord, that's not available with us.
Good. Yes. We are allowing 30,000 with one surety.
Bless you.
Well, my objection may be recorded, my lord.
Yes, and recorded. Item 3.
For bail hearing, item number 3.
May it please me, lordship. The applicant number 1, Vikas Pegu, has been arrested on 6/8/25. Therefore, the matter has become infrastructure on his part. And it has come to our knowledge that Sarsit has been fined, lordship.
Rashid has been fined. Then you go before the trial court.
My lord, here in this matter, my lord,
Lordship, there may be kindly fixes your lordship convenience as the conducting counsel, Mr. Pierre Sharma is out of station.
No date. If charge sheet Mr. Bosho, has charge sheet been laid?
my lord, city is available with us, my lord, along with my lord bail objection. My lord, only the part is that there is one note, my lord. But that is my lord stated as my lord, this matter is my lord, that is the Jonai PS case number 37/2025. But in the note, it is stated as my lord 39/2025. That may be my lord typing mistake, if, as because my learned friend has stated. In the meanwhile, my lord, I will take instruction whether in this case, my lord, the subsidy is late or that is another matter, my lord. Because one, my lord, another FIR was also lodged, my lord, that is 38/25 by the present, my lord, petitioners, man. They have lodged another FIR, my lord. Otherwise, CD is available with us, my lord. But that is 39.
37, CD of 37.
37 is available with us, my lord, along with a bail objection, but my lord, there one notice there where my lord it is stated that also the absconding accused person, so and so, all the name of the present petitioners are
No,
there.
Mr. Bashaw,
My lord,
if CD is available with you,
my
how
lord.
charge sheet can be filed?
My lord, nowadays, my lord, entire city, they didn't, my lord, submit, my lord. Some, my lord, that is the.
Okay, then you take instruction.
Yes, my lord, for that reason only, my lord.
How much time will you take?
My lord, I can take my lord, tomorrow maybe also fix, or if my learned friend is stated that my lord, he needs some time, my lord.
How much time is required by
week,
petition?
1 week.
1 week? Okay, heard, Mr. What is your name?
Espego.
SK?
Espego.
Pegu, learned counsel for the petitioner. Also heard Mr. K. Bashaw, learned additional public prosecutor. Learned counsel for the petitioner has submitted that the petitioner number 1 has, in the meanwhile, been arrested. Hence, this application has become infructuous as against the said petitioner. Stop. With regard to other petitioners, he submits that it has been informed to him that charge sheet has been laid in this case. On the other hand, learned additional public prosecutor has submitted that the case diary of Jonai PS case number 37/2025 is available with him. However, he seeks some time to take instruction as to whether charge sheet has been laid or not. The prayer is allowed. Let this matter be listed. When, Mr. Bashaw?
Any date, my lord.
Next Tuesday.
My lord.
Listed on 28/2025.
Till then, my lord, CD will be retained, my lord.
Till you can return back the case diary.
My lord.
The case diary may be returned back to the investigating officer. Second half. Or on not on Tuesday, 21.
21, my lord.
21.
Then, my lord, we will retain the CD or send back, my lord.
Send back the CD.
Okay.
You want to retain it?
My lord, because today is my lord 13, my lord, and if my lord we send and if it is not my lord that is succeeded, then my lord again we have to take further.
Okay, the case diary shall be retained
My lord.
till next date.
And in the meanwhile, my lord, we will take telephonic instruction.
Okay.
Oblige.
Oblige.